Armin, my goodness. How did I forget the live stream? It's supposed to be ingrained in my brain. All right, I believe we are live streaming right now. Yep, we are good to go, Judge.
Okay, so we have already discussed the need to disclose any conflicts of interest. No one has indicated that they have any conflicts, so we may proceed. Our last meeting was September 11th, at which time we went over the draft that Brian had prepared. And at that time, I think we made some good progress, and the focus was on inquiry number 4 and then inquiry number 6 primarily. And that was dealing with simultaneous notification of an attorney to opposing counsel, and then the other was contact with a judge or communication with a judge in an emergency situation. So Brian sent out revisions first of last week or a week ago. So hopefully everyone has had time to look at those. It came out in just a regular version plus a red line version, so you'll be able to see what changes were made. So Brian, I will turn it over to you at this point to talk.
All right, thank you. I'm going to go ahead and share my screen so we can just all be certain that we're looking at the same thing here. So as Judge said, we have, I guess we want to make sure we're all looking at the document. You guys can all see that right now? Okay. Yes, we are, we're looking at inquiries number 4 and 6, and the big changes really were, I guess, from the last one. We had kind of 2 options really for inquiry number 4, and it was all about the simultaneous provision question, whether or not simultaneous provision of a communication really exempted something from being classified as an ex parte communication. And after the subcommittee's discussion, we determined that no, simultaneous provision, specifically that exception that previously existed in the rule, has been removed, and really kind of been removed for good reason. So the way that we've come out now, we've chosen the option that basically says if lawyer, the inquiry stating or asking the question, basically if lawyer simultaneously provides a communication to a judge, is that authorized under the rules of professional conduct if the lawyer basically copies opposing counsel on an email? Suddenly, is that supposedly okay, or at least exempting it from ex parte communications? And we answered no to that, basically noting that the rule has changed. The rule now requires, or I guess defines, ex parte communications as communications that occur in the absence of an opposing party, without notice to the party, and outside the official record. And so with that said, simultaneously providing something, namely copying opposing counsel on an email or text message, does not, I guess, satisfy this requirement that the communication be made essentially in the presence of the opposing party. It also does not satisfy the notice requirement. So the thing that we have here, we chose the option that basically says no, like I said, but there's some questions that I posed here as kind of comments to the document that I sent around, and they kind of came in part from some thoughts that Judge Rader shared with me after I sent out the first revision following our subcommittee meeting. Judge very correctly pointed out that some of this, I guess, the way that I drafted it may have led to some confusion. So I tried to tweak the language a little bit. And it's really this section here. I'll start with this very first one, where we're kind of explaining, I guess the opinion takes the opportunity to explain why simultaneous provision of a communication should not, or does not, exempt something from being classified as an ex parte communication. I think the reason, there's kind of a reason for this, and namely because that's how our rules have been. Our rules have said that simultaneous provision basically serves as an exception to the definition of ex parte communication, that it's not going to be ex parte if you simultaneously provide counsel with the communication. But I think based upon our conversation, it seems like we all realize that that's not entirely correct, because sometimes providing something, even copying opposing counsel on an email or a text message, can result in the opposing counsel not getting or not receiving the message at the same time. Maybe technically they have been provided it in their email inbox, but that doesn't mean that the opposing counsel is actually reading it at the same time as the judge. Oftentimes it may very well be the case, but it's kind of a flawed presumption. And so also we kind of noted that that sometimes folks use that simultaneous provision exception to gain a strategic advantage, to essentially, if you copy or you send an email to the judge at 9 o'clock at night saying, I need a continuance, but you copy opposing counsel, well, that's not technically a part of ex parte communications under the old rule. There's just still the question of whether or not that is prejudicial to the administration of justice, but that that there were lawyers that would essentially just kind of shoot off a communication to the presiding judge, maybe requesting a continuance or making some other request, and thinking, as long as I copy opposing counsel on this, then I'm okay. And that's what these two sentences try to explain, kind of I guess, why that simultaneous provision language in the old rule was flawed and why it was taken out, and kind of where the rule is now, to justify this answer, because this answer is going to be different than how we used to act, how lawyers used to act. So we're kind of providing that additional information. My question to the subcommittee is really, is this even necessary? Maybe it's helpful to understand the opinion or the thinking of the subcommittee here, but it's arguably just unnecessary to get at the answer itself of what the answer is now in this opinion. So I think that's one question that we need to answer about this inquiry and answer number 4. And then the other one, really,
Brian, okay. Well, on that question, I know I don't get a vote, but my thought is that particularly if this ethics opinion is going to revoke all of the prior ethics opinions on this topic, I think it would definitely be helpful to include that explanation, because there are going to be lawyers out there who have engaged in this kind of conduct based on the prior iteration of the rules. And I think it would be, because ethics opinions are essentially an educational tool, I think it would be really valuable for those lawyers to be able to see, yes, this used to be a thing. No, this is no longer a thing. And here's a little bit of explanation as to why. So I'm definitely in favor of including that bit of text in the opinion.
I tend to agree with that, Brian. I think that most lawyers are looking for clarity and they're looking for direction and guidance. And I think this makes it clearer. And I think it would be more helpful.
Brian, can I?
Yes.
Y'all may have already talked about this, and I apologize. I couldn't make the last meeting. Work got in the way.
It does that.
So, yeah, I'm all about making sure that lawyers understand the rule. That's very clear. Can't get around it. Was there any discussion about making the answer to 4 and 6 the same? And just saying, no, you just need to, why is it easier to text a judge than it is to text the TCA or opposing counsel? My point is, if you need to tell somebody, whether it's an emergency or if it's the day before, that you need a continuance, everybody knows the email address for the TCA, everybody, or clerk, everybody knows. And most people know the clerk's cell phone.
Right.
And most people know opposing counsel's cell phone. So my point is, why is 4 and 6 different? I just reading it, because since I wasn't at the last meeting, I just sat down and just kind of read it. I got a little confused by the explanation in 4. I had to read it several times. And I know the reason behind it. So I'm just thinking, why don't, and I assume somewhere, and if it's not, it should be somewhere in the preamble or the beginning of it, it should say this all, if a judge can certainly set the ground rules different from this, but if not, if you want a continuance, and for some reason, you always notify opposing counsel and then you notify the TCA or the clerk. I guess I don't understand why there's a difference in 4 and 6.
Well, I think we, to jump down to 6, I did revise 6 after the last meeting. And the way I read it, I think they are similar now. They're coming out with the same answer of, can a lawyer, because we changed the question, or I should say, before we had the questions kind of posed a little differently, and I merged the inquiries together just to basically set the stage of inquiry number 6. May lawyer A contact the presiding judge, copying opposing counsel, to inform the court of his inability to attend? And we are now just saying no, just a blanket no. And referring folks back to answers that are in answers number 2 and number 4. So I think we tried to make them more coherent and reaching the same conclusion that even if it's an emergency, you still cannot just contact the presiding judge. Even though we recognize the rules are rules of reason, but a lawyer is still supposed to comport themselves with the rules, even in these emergency situations. Then we offer the trial court administrator or the coordinator or some other court personnel as an alternative person for folks to contact.
Maybe I'm looking at the wrong one, but on the answer number 4, the last sentence says the primary solution for this scenario would be for lawyer A to provide reasonable advance notice to opposing counsel of the need and intention to send the communication to the judge, followed by lawyer A copying opposing counsel on the eventual communication to the judge. Is that no longer in there?
No, that's in there.
My point is that is different than 6. I mean, it's saying you can communicate with the judge. I'm thinking the day before you'd have less reason to even communicate with the judge, because you could certainly, and this scenario is not the emergency situation. And so I'm wondering, and it's not an emergency situation. We communicate with the TCA and the clerk all the time. We never, there's no need. And I don't know that our judges want us to be communicating with them by text or email about scheduling matters. So, it does seem just different to me. It just seems to me that for lawyers, they need to make sure they have a clear rule and they understand it. And then they don't have to worry about getting in trouble with the state bar. And it just seems to me that the rules should be, whether it's an emergency or whether it's the day before, unless the judge is giving you specific instructions otherwise, and I get that. Judges control their courtroom, that you contact opposing counsel and you contact the TCA or the clerk.
Yeah, I think the answer number 4 with that last sentence is kind of based upon the notion that notice has been provided. And so I guess I'm trying to understand if the concern is more so just reaching out and speaking to the judge at all. I don't know that the rules necessarily prohibit speaking with the judge at all. It's that if you talk to the judge without notice or in the absence of opposing counsel or off the record, then that's going to be ex parte. But in theory, under the rule, if you provide notice to opposing counsel, then you can communicate with the judge per the rules. It's still, I don't know if we want to set a different standard that just says you should never speak with or never communicate with a judge about scheduling matters. And that would be I think a different approach. I don't know if the subcommittee wants to kind of alter their approach here and their interpretation of the rules, but just based upon the definition of ex parte communications, I think if you provide notice, in theory, you can communicate to the judge, even if it's about scheduling matters, since we don't specifically exempt that. So
I know that makes it confusing. It just, it still confuses the issue. And I think that the practicing bar just needs clarity, needs to know what can we do, what can't we do. I mean, if the judge says to us, I want you to send your orders, email simultaneously, that's fine. If the judge wants a memorandum sent to you and tells you that, and everybody knows that, that's fine.
Right.
These are unsolicited communications with judges. And I just think that lawyers need, because trust me, there's a lot of texting going on with judges ex parte.
Right.
It's happening because it's so easy. And I just think it undermines the public's perception of impartiality, and that comes out that the other side's been texting the judge. I just and I just feel like, I don't know, I just want a simple rule that everybody can understand and follow. And why is it easier to text a judge or email a judge than it is the TCA or the clerk if you need to continue your case? I don't understand why it's easier to do that.
Right.
Well, Marcy, my thought on this in terms of looking at that last sentence in section 4, is I look at this in terms of federal court communications, that there isn't a TCA. There is a clerk, but it's the clerk in the judge's chambers who would be setting a matter. And so it isn't uncommon that something, that there's a scheduling issue, or there's something that comes up and that the court needs to be aware of. And the practice, I would think that what the rules allow and what this is encouraging is, I email the U.S. attorney and say, hey, I've just realized I'm supposed to be in the Eastern District on the day that this judge just set this for sentencing. Are you okay with me emailing Ruth, the judge's clerk? And then they say, yeah, that's fine.
I think that's what I'm saying you should do.
Isn't that what they say the primary solution for this scenario would be? Lawyer A to provide reasonable advance notice to opposing counsel of the need and intention to send the communication, and then the lawyer copies opposing counsel on that communication, right? No. Isn't that what they're saying happens?
No, it says communication. It says communication to the judge. So I don't know that your clerk doesn't your clerk get notice if somebody needs a continuance? They don't email you directly or text you directly about continuances, do they?
No, they don't. But for ethical reasons, my law clerk is considered me. So when you communicate with my law clerk about this, you're communicating with me.
Really?
I think it's somewhat of a fiction. The judicial canons say that, your staff is an extension of you and you're responsible for them and what they do. So if they're engaging in misconduct, and you find out about it, you got to do something about it. You can't just sit back and let things happen. Judge Rader, am I wrong there?
No, I've heard that before also. Yeah.
But if the rules of professional conduct give the lawyers the right to communicate the need to reschedule or continue to a TCA or a clerk, then I don't know that they would be doing anything wrong.
Well, when I communicate with counsel during a hearing when a case is new, I make very clear to them so that there can be no misunderstanding. Do not send me emails. Do not send me text messages.
Right.
If you need to communicate with the court, you either send it to one of my law clerks or you send it to my admin. You do not communicate with me directly. So if they do that, they're in trouble, but for a different reason.
Right. That's the way it should be. And that's the way I think we need to have it in every court.
Yeah, but I think the practical problem is some judges don't have the kind of support staff that some judges do.
I'm in Johnston County, okay? I'm in a rural county, okay? I can tell you right now, I know who the clerks are. I've got their email address. I have their cell phone numbers. I can text them. I mean, that's how it works in, rural Johnston County. The clerks, the clerks. They should be teaching that in law school if they're not, by the way. You know who your clerks are. You know how to get in touch with them, and they know who you are. And I just feel like, I think this is not clear. And I think that's what we were trying to do, is to come up with something that was very clear, no slippery slopes. Everybody gets the rules. Everybody understands the rules. And you if you've got to continue your case and you can't, well, first of all, mostly it's done at calendar call. You know, and even now with Zoom and WebEx calendar calls, you know, it's on the record, you know, calendar call, and you ask for continuances. So we're talking about if you find out the day before, well, most of the time people just, they deal with it on calendar call, you know, instead of texting judges, you know. If it's an emergency, I just don't know why you can't get in touch with opposing counsel or the clerk just as easily as you can the judge if it's an emergency. I guess I'm having a hard time understanding why you can't just communicate scheduling issues with opposing counsel and the clerks and not the judge. The judge shouldn't be involved in scheduling stuff. I mean, that's.
But I think that in looking at this, when I made that reference to the way it's handled in federal court, there is no TCA.
Or clerk.
Right. That
or clerk.
the clerk, but the manager is an employee of the court. And I would view reaching out to the judge's clerk as an extension of the judge. So I wouldn't think I could any more directly email the judge's clerk ex parte than I could the judge himself.
Well, I think there's a distinction. One is talking about a law clerk. One is talking about a clerk of court.
Right.
Yeah.
Okay, maybe that's the problem. I'm sorry. Yeah, I'm thinking about more of the administrative person.
Right. Right. And there are not trial court administrators in every county. There are only in about 8 to 10 or 11 counties.
We don't either. We don't have one either.
Yeah, but there are trial court coordinators, and there are, you know, judicial assistants, and there are clerks of court.
I mean, Marcy, can I ask a hypothetical?
Yeah.
You know, if you do have a real emergency where you're, for instance, in an automobile accident on the way to court, okay?
Right.
In order to communicate with the court once it is in session, how would you, if you had a real emergency, try and get word to the presiding judge that you had been?
Call my office, get my office to go take care of it, and go over to the courthouse or get somebody to go to the courthouse and talk to the clerk. The judge is on the bench. I mean, to say that the judge has got a cell phone right there, you know, waiting for calls to come in, they shouldn't. You know, I mean, the best way to get in touch with the court quickly is to let the clerk know there's a clerk in the courtroom.
Yeah, I guess my point is, when I was practicing and I would go to a remote county that is not Forsyth County,
Right.
I would have literally no idea who the courtroom clerk assistant was or what their phone number is or how to get in touch with them if I had an emergency. I mean, just as a practical matter, there's a home field advantage there.
But you would call your office probably if you're a paralegal or whoever's there to help you do that. I mean, that's what I would do because I can't live without my paralegals doing that. But I don't know. I'm just. I
mean, what I hear you arguing for, and maybe this is something that, you know, we can talk about, is adding some language in here that says, you know, let me just say it, it won't come out right, but direct communications with the judge, whether they're ex parte or not, are frowned upon. If you need to communicate with the court about a matter, it should be with a non-judge, somebody who is not a judge.
Again, I think that that would be easier for lawyers to understand. I think that, you know, when we write these rules, you know, lawyers need to know what they're supposed to do and what they're not supposed to do. And then if they violate them, then that's their own fault because they should have understood it. But if you give a rule that's not clear, it, you know, it opens the door for, I don't know. I just guess I'm just from a practical, just having a hard time understanding from a practical standpoint why judges need to get involved in scheduling stuff. I just don't understand that. And it just creates the appearance of impropriety. You know, if it comes out that the opposing counsel has, you know, stands up in court and your client's there and says, well, I texted the judge over lunch and told him I couldn't be here. And then your client's sitting there going, why is he texting the judge? You know, that's just not good. I just feel like that's why we have administrative people. That's why we have clerks and others in the courthouse, that they deal with situations like this. So I don't think judges deal with it really, or should. I mean, they got a lot of other more important things to be doing.
So Brian, could this be corrected or maybe made clear or resolved by using most of the sentence that you used in number 6, which basically says in such a scenario, a lawyer should still refrain from communicating with the presiding judge and instead attempt to communicate with the clerk, trial court administrator, trial court coordinator, or some other court personnel. Do you think that would help clarify that we really should refrain from communicating with the judge on this issue schedule?
I like that language. I think it's good, personally.
Yeah, I think it could. I think, and this is kind of getting to the the general notion of what to do with scheduling matters. That's something that like the model rules, if I'm remembering my model rules correctly, I think they exempt scheduling matters from any sort of prohibition. And our rules only prohibit ex parte communications, the manner in which we speak with a judge. Not necessarily drawing a distinction on substantive versus administrative matters. So if we wanted to kind of make the point here in inquiry number 4, that essentially copying opposing counsel does not make everything okay. That doesn't exclude it from being an ex parte communication, which it previously did. We've made that point. But we want to make the additional point that when it comes to administrative matters, lawyers should still refrain from communicating with judges. I don't know if we can have an outright prohibition, because I don't know if the rules really kind of enable us to have an outright prohibition. I don't know if anybody feels differently, that we could actually say lawyers shall never speak to judges about administrative matters.
Well, I mean, the very first sentence says absent prior authorization by the law or presiding judge. I mean, I don't think we're trying to say you can't speak to judges. I think it's just
we're just trying to discourage the administrative matter. I guess that's a little bit of my confusion. Are you saying that lawyers should they be prohibited from speaking with judges on administrative scheduling matters?
I'm just saying I don't want to have another rule that's confusing like the other one. I mean, I don't want us to go full circle back to another confusing where people come at me and say, what in the world do you mean? What are you saying to us? And it's like,
Well, it seems to me like the reason we had an inquiry number 6 was to try to address whether there is any difference. Like, I think inquiry number 4 as it stands is fairly clear. Inquiry number 6 was as I understood it, to address whether anything about any of the preceding general propositions is altered in the case of a true emergency. And it seems like if the answer is no, maybe a better way to say it would be either to combine it with one of the inquiries above, or to just say no, see above, and include that language that we were just looking at about, contact court personnel about administrative matters, do not contact the judge. Include that in one of the more dense answers. I mean, that was my understanding about why we had number 6 at all.
I think it's the last sentence in 4 that I think makes it confusing. Because I mean, it sounds like you're saying no, but then say the primary solution would be yes.
Right. So I wonder if we did something like, well, hang on a second. I'm going to back that out. It's almost like we want to say the primary solution in this scenario is to contact court personnel. Opposing counsel.
I would suggest that as 6. The primary solution would be the same as 6, is what I would suggest.
I think one of the intentions here was that I don't think a lawyer is prohibited from calling the other opposing counsel and saying, we need to meet with the judge on scheduling X, Y, or Z.
Right.
And this is to let you know, I'm going to reach out to the judge and request an opportunity to talk about scheduling. Because you've given notice to the other side, that would then not be ex parte.
Why
And
would-
what this was addressing was the situation where the attorney wants to talk to the judge about scheduling, but instead of calling him and saying, we need to schedule a time to meet, or we need to talk by phone, I'm just going to copy you on it simultaneously through a text, which is what this is addressing, trying to say, no, you can't do that.
So Judge Wright, are you saying that it's normal for a lawyer to contact the other lawyer and say, I'm going to call the judge to set up a time to talk about scheduling?
That happens. Sure.
Okay, so I've never, I mean, that to me,
Yeah.
why is that? Is that normal? Is that right though? I mean, I don't know. I
If
just,
everybody's present, I think it's right. But
I mean,
most of our scheduling is done, like in your situation, through
Yeah.
family court
yeah, I mean, well, through clerks
or trial court administrator's office. But
yeah, or calendar call.
Yeah.
You say, okay, are you available on Tuesday or Wednesday? And everybody's
Right.
on record and you've got everybody there. I just, again, I think you say a judge can change this. I mean, the judge, if the judge wants to say, I mean, the judge has control of the courtroom. They can say,
Sure.
but I just don't. I mean, if a lawyer called me up today and says, look, I want to let you know, I'm going to call the judge today and talk to him about setting up scheduling, I don't think that would be right. Just because they made the phone call to me and said, and told me they're going to do that, that doesn't make it right.
No, I
I'm not
agree.
comfortable with them calling the judge then and talk. I mean, I'm just not. The way you would do that is if there's a scheduling, you just email the clerk and copy the other lawyer on it and say, look, we need to talk about meeting with a judge. That's how we do it. You know, you don't.
In that scenario, would you not say, I object to you doing that? I mean, I kind of think that that's the purpose of notice, that then you can, and I think a call may be a different scenario than an email where there's at least simultaneous notice. But if somebody says, hey, Marcy, I'm going to send an email to the judge about scheduling, you have the opportunity to be on notice and respond to that person and say, no, I don't want this to be done over email. I don't know that I'll have the ability or the right to respond. And then you also have the ability to see that email come through and you can say that needs to be discussed at our next hearing and we can deal with the trial court administrator. I mean,
Missy, what if you're in
that
mediation?
aspect notice is,
I'm sorry, didn't mean to interrupt you.
no, please go ahead. Tell me.
What if you're in a mediation, you can't take the call or you can't get to your email? I mean, you know, we're in mediations, we're in trials. I don't sit in front of my computer and I don't keep my phone right in front of me because clients would be very upset. You know, if you're looking at your phone when you're supposed to be representing them. So I just, again, in the real world, if you got in my world anyway, or if you've got a scheduling issue, you deal with that with the clerk and the clerk can talk to the judge. That's what happens. You don't email the judge directly. Anyway, I don't do it. I mean, I'm just one member out of this group. I just know that I have lots of lawyers that come up to me and say, what do you mean by this? What does this rule mean? You know, it's kind of like when we were, Brian, you know, we went over and over and over about when you could do these accolades. And we finally came up with a rule that was clear. Right. You know, lawyers can, but I don't know how many different drafts or how many, we just, and I think when it comes down to it, there's got to be some clarity to this. And I think that Rule 4 is not clear to me as it's written. That's just, and I know there's been a lot of thought put into it. I'm sorry, but I don't know.
I'm doing a little bit of editing right now to see if I can actually get something that might reflect.
But nobody else may agree with me on the committee. So I mean,
I see what you're saying. I mean, I think the thing that we're reconciling here is it's like the general notion that what you're saying, that essentially lawyers should refrain from contacting the presiding judge about administrative matters. We may not be able to say the rules prohibit that, because I don't think that's accurate, but we can still offer the opinion that lawyers should attempt to not contact a judge about scheduling matters if they can avoid that, if that's not necessary. Certainly not frivolous scheduling matters, but of course that gets into a subjective interpretation of, well, are you just contacting the judge because you can't make it to court tomorrow, or are you contacting the judge the way that Judge Rader described, that we need to figure out some scheduling here, and so opposing counsel, I'm just letting you know I'm about to reach out to the judge. I'll copy you on that, and maybe we need to have a sit down. That would allow something for counties that need to do that to still be able to do that. But we still want to offer the perspective similar to inquiry and answer number 6, that if you can avoid it, don't talk to the judge. Talk to opposing counsel, and if you have a scheduling matter, like you need to request a continuance, request the continuance by filing something with the court, or contacting the TCA or whoever it is. So I'm wondering here, I'm going to share this version that I just typed up, and I don't know if this is what we're talking about here, but what I did was instead of saying that this primary reason, we say like the primary solution for this scenario is for lawyer A to provide reasonable advance notice to opposing counsel before communicating with the judge. And I think that sentence is, instead of saying the primary solution, maybe just by calling it one solution, is to go through this and basically satisfy the maybe not satisfy the definition of ex parte, but satisfy the requirements for the communication to not be ex parte. That is one option to go through here, but we still want to provide the last sentence, which is new here. In general, however, a lawyer should still refrain from communicating with the presiding judge, and maybe actually now I'm seeing this about scheduling or administrative matters, and instead attempt to communicate his unavailability to the clerk, the trial court coordinator, etc. Aside from the judge. Essentially, that's the guidance that we offer at the end, to just encourage folks, try to avoid speaking directly to the judge if you can, but if you have to, provide notice to the opposing party. I don't know if that is better or if that confuses things more. I don't know if I'm hitting your concerns, Marcy. So I'm kind of working on the fly here.
Yeah. I feel like I've spoken too much. Y'all go ahead, and somebody else needs to speak up. I don't want to. I have one thought. Could you make the in general one the rule and the other the exception? Like you should attempt. I mean, like if for some reason you can't get in touch with a administrative person or opposing, I don't know. Again, I just
switch that around.
I don't know. It's just a thought. It just seems to me that you should first try to deal with it as an administrative matter. You should deal with an administrative person. And then if you can't, I don't know.
Well, and I think the emergency one in number 6 also is kind of based upon the notion that providing notice to opposing counsel is kind of out of the question because of the emergency situation. You only have, if you are in a situation where you can really make just one phone call or shoot one email off, that under 6, we're saying you still should not send that to the judge.
Yeah.
You should send it to the TCA or court personnel. But that's because notice cannot be provided. If you can provide notice, then at least under the rules, you would be theoretically permitted to get notice to opposing counsel and then send out the communication to the judge saying, I just got in a car accident, and I've already notified opposing counsel I will not be there today.
So Brian, notice for 4, what does that mean? Does that mean that the actual notice? Does that mean that the opposing counsel actually received the advance notice? Or is just calling the office and they're not even there, leaving a message or sending an email and that they don't get? Is that notice?
I mean, I guess that's a great question. I think what's advance notice for, getting a TRO or something? It's making an attempt to notify the party, but I think to get a TRO, there isn't a requirement that you prove the person actually did receive the notice and is aware of the hearing. I think you have to make a reasonable attempt to communicate that notice. I don't know if it's been a while since I've gotten a TRO, so somebody please correct me if I'm wrong. But I guess that question of notice, I don't know if we want to specifically define it, because I don't know that it's really defined elsewhere. And I know that would be helpful to have for a really clear rule. I guess I just don't know if that's something that we can pin somebody down to say notice equals this. We can always write it down and see what the reaction is going to be. I just don't know I'll throw it out to the other subcommittee members. What do you all think?
Brian, one thing I would say about the text that's on the screen is that last sentence. I think there's way too much equivocation. I would just say, otherwise, something like, otherwise lawyer A must provide reasonable advance notice to opposing counsel, like instead of having all this sort of vague language.
Are we saying, I'm sorry, go ahead.
The one thing that, and maybe one of the longer term members of this committee might be able to give guidance on this, but sometimes I recall a phrase being used in the ethics committee that we aren't trying to tell people how to practice law, or we're trying to define the rule, but we're not telling them how to practice law. So I think that we may be getting into a little bit of a sticky wicket here in terms of saying, first, you should do this, and second, you should do this, right? Whether it's you should call the TCA or you should call, I think that we should reiterate the rule. We should clearly give guidance on the rule without giving sort of the step-by-step instruction in terms of exactly how to handle the situation. Does that make sense?
I guess I should say I respectfully
You disagree?
disagree. I like you, Missy, and I don't want to hurt your feelings. I just feel like
I agree with the thought, Missy, that yeah, we don't want to tell people what they should do or how they should do it, but I think they are looking for some guidance or some clarity into what it means, and I think this sort of tells them, you don't have to call the TCA or you don't have to call the clerk, but you need to call somebody other than the judge. I mean, I think is the point here. And looking back under the old, I guess it was 13 FEO, I can't remember.
yeah.
Where you had the 4 exceptions, one of them was scheduling and administrative matters. So there was a distinct exception for that. And then 3.5 was changed to eliminate that. So the pendulum has swung quite a bit, and now we're taking a big step saying that simultaneous communication is not adequate. I mean, that's not adequate notice. It's not going to fly under this rule. So I don't know that we can say no communication at all.
And Missy, unfortunately, not all lawyers are, I don't know, you're dealing with all kinds of lawyers out here. Would it be, if we say you should try first to do the TCA and the clerks and all that, are we saying that communicating with the judge about a scheduling matter is only after you've tried to do these other things, or is that still okay to do it that way? As long as you give reasonable advance notice, then we get into that, what that means. Are we saying that you can still contact the judge about scheduling matters if you can't get up with the clerk, or I don't know. I'm just still trying to, I still say, I think in practice, people do this through the clerk, but.
Are you comfortable with the language that's on the screen now?
In general, a lawyer should refrain from, give me 1 second. I guess I'm worried that there will be confusion. Are we saying you can do A or B, either one? Are you saying that you can do A, meaning the red? Okay, red is A, green is B. Okay, so are we saying you should do A first, and if you can't do that, then you can do B, or are we saying that you can do either A or B?
I would think that the opinion, if somebody called for advice under this opinion, I think I would advise somebody that the A essentially is the preference, but it's a should. It's not a shall. It's not a you shall first attempt to do this, first attempt to do A, then you may proceed to B if that doesn't work. I think I would advise somebody that the ethics committee wanted to encourage lawyers to leave the presiding judge out entirely, but that the rules do permit you to contact directly with the presiding judge if you have provided advance notice to opposing counsel of your intention to communicate with the judge.
You know,
I guess maybe that's a question. Oh, go ahead,
there
Judge.
were 3 paragraphs kind of before we get into the specific questions on this FEO that talk about the history and why we're doing what we're doing and that kind of thing. Right. I really wonder, to the extent this whole issue of going through the clerk and not the judge makes sense and would be something that you would say to somebody who called asking your advice, if that isn't a great place to put this kind of admonishment that the way to avoid getting into trouble and having these kinds of issues is by communicating with the clerk's office or the TCA and not communicating with the judge. And say, but these, the upcoming questions deal with the issue of where you feel that you must communicate directly with the judge.
I think that's a great thought. Setting the stage essentially that really is an appropriate place for the ethics committee to offer that sort of guidance and encouragement. But then to set out, like you said, where you can't take the preferred path, let's address the situations that could commonly come up as far as needing to contact or feeling like you have no other option but to contact the presiding judge. What do the rules allow? Because the rules do allow communication with the judge. They just prohibit ex parte communication with the judge.
Right. Yeah, that first sentence of the 3rd paragraph says, the following scenarios address the lawyer's responsibility in communicating with and maybe we just say directly with a member of the judiciary.
Right.
and then put that language you drafted so ably before that.
Yeah. What do you think of that, Marcy? Do you still want a kind of a hard and fast rule of just, well, no, yeah, I wonder, would that offer that clarity? Because I think you're right that, you know, lawyers are going to get this and they're going to wonder, well, what am I allowed to do? What am I prohibited from doing? And we know that some folks will take advantage of that. I'd like to think that, you know, those folks will be the exception and not the rule. But in an effort to provide that sort of guidance, do we need to, I guess, similar to what we did before, in that I think the opinion that you're referring to, Judge, was, I believe it was 97 FEO 3. It's one of those FEO 3 or 4.
Yeah.
But we provided administrative matters as an exception. Should we clarify that administrative matters should, you know, I guess, I don't know if you want to say even absent exigent circumstances, but just administrative matters should never go to the presiding judge directly. I don't know if that's something that this subcommittee wants to entertain. I see a grimace.
But that's how I feel about it, to be honest. I mean,
Right.
I can't tell as a practicing lawyer. I have so many things to worry about. I don't need to worry about underhanded lawyers trying to have communications with judge. I got too many other things to worry about. I mean, I just don't understand. I wish somebody in this committee, maybe Mike, you can tell me, what is an example of when somebody would need to have a communication with a judge about a scheduling matter? Give me an example. Why that? Because we don't deal, that's not how I practice. Judges don't deal with outside of, the only time the judge deals with scheduling matters is during calendar call. You know, we have calendar call for, you know, whatever, 1 week or 2 week session, and people say they can't do it or they need a certain day, and then the judge deals with it. But I just don't, I'm just trying to figure out when you would need to be able to call the judge to talk about a scheduling matter. I just don't understand.
Well, I think Judge Rader mentioned the TRO scenario. That would be the big one on my list.
But it says unless otherwise, that would be covered by another law, right? That would be.
Well, there's nothing in Rule 65 that says that, you know, an attorney can call the judge and talk to him about it. It just says it can be issued on an ex parte basis.
Right.
Now, maybe that gets you pretty far down the road in being authorized to do it. You know, it assumes that you can communicate with the court without opposing counsel present, but that's the only one I can think of. And again, this is not an issue. Nobody communicates with me directly about scheduling matters. They go through my clerks.
Yeah, that's my point.
Same here, but I don't think there is any, and I may be wrong, Brian, you correct me. There is nothing in the state bar rules that says a lawyer cannot communicate with a judge. They just can't do it ex parte.
Okay.
That's correct.
Okay.
I mean, isn't that correct? So what we're doing here, particularly in Rule 4, was trying to clarify that trying to communicate with a judge and sending the simultaneous text to the other opposing counsel is not going to fly. That's not going to get around the ex parte problem.
I mean, and arguably, Judge Rader, let me make sure my thinking cap's on straight. Nor would sending a scurrilous letter about the conduct of opposing counsel or the opposing counsel's client, a litigant in a case, sending a letter to the judge complaining about somebody and copying opposing counsel at the same time. Right, that's a communication with the judge directly, not through a motion or proper filing with the court, but it's not ex parte. This rule doesn't really speak to that unless I've, you know, we've been focusing on 4 and 6. Maybe it's covered in one of the other ones.
Yeah.
Well, and a scurrilous letter might be considered conduct prejudicial to the administration of justice under Rule 8.4, I think.
Yeah.
Right.
There's another
Right.
inquiry that says you can't argue the merits.
Yeah.
Okay. Thank you.
Yeah, that particular opinion just kind of goes on about the merits really are just off limits in general.
Right.
You know, that ex parte or not, you just shouldn't do. That's going to be an 8.4D situation.
Yeah.
But I think it does raise the interesting question of, you know, the kind of the quote unquote old school method of bringing a letter, bringing something to the court, copying opposing counsel, you know, but that's considered simultaneous provision if you put it in the mail the same time that you go down and bring it to the courthouse. And I think that just that method, whether it's an email or a letter, unless you have given that notice, that would still qualify as ex parte here. Just because it's hard copy, I don't think exempts it from the general requirement that it be made in the presence of the party and with advance notice and so forth. But nevertheless, so I think if we can, in kind of looking at this, I think maybe there may be some more drafting to go here. But I'm curious, do we want to have I think maybe a question that we need to answer is this question about administrative and scheduling matters. Is that something that we want to distinguish? Because right now we don't necessarily say you cannot speak to a judge about administrative or scheduling matters. If we want to say that specifically and kind of, I guess whether we have to decide, is it a hard admonishment or is it a soft admonishment? You are encouraged, generally you should refrain, but it's a should, not a shall.
Right.
And we could either do that as the soft one, or we could have the hard, no, administrative matters and scheduling matters, they shall not be communicated to the presiding judge. There's a reason why there's court personnel, kind of thing. And that would be essentially a new interpretation, certainly, potentially a new rule. And of course, I mean, that's not something to just kind of shy away from as well. If there's something that we should clarify in the rules, that scheduling matters should never be communicated to the presiding judge unless authorized by the judge, then that is a possibility too. I can do some research on what jurisdictions, if any, have adopted something like that. I don't know any off the top of my head, but or I can't recall any. I know I've looked at them, but it's possible that some other jurisdiction already says administrative matters never need to go to the presiding judge. That's for court personnel.
I don't think we should take that away. I mean, I'm not advocating for something that drastic. I don't think. I just guess what I'd like to do is my thought is you should try to deal with your scheduling matters with court personnel. That should be the general rule. And then if there needs to be discussions with the judge about scheduling matters, then, I guess this is the second part, but I would like that to lawyers to be encouraged, because again, it just takes time and energy away from dealing with the merits of our cases if we have to constantly deal with emails and talk with the judge, or it's just I don't want to take away Judge Robinson or Judge Rader. Well, I guess you're retired now, but judge's ability to talk with folks. I mean, I'm not trying to do that at all. I'm just trying to.
Well, no, I agree. I agree with the general premise that lawyers should refrain from communicating directly with the judge outside the record. I agree with you on that.
Yes, we've got that language there. We moved it, right, and put it into 4.
Right.
Yeah, and I guess one option is to take this language, as Judge Robinson suggested, and actually put it up at the outset.
Mm-hmm.
That we start the opinion off by saying, in general, lawyers should refrain from communicating with the presiding judge, particularly on scheduling matters. and we know we can, that's not to say that we need to remove it from 4. We can kind of reiterate it again because people will be into the thick of the opinion. So how about I'm going to make a revision. I'm going to, and I'm not going to try to do it right here, but I'll sit down and see if I can get the language to flow in the beginning part, to put that general encouragement, refrain from communicating with the presiding judge, particularly on scheduling matters. But, essentially, if you have to speak with the judge about something, then, we engage in the following analysis. Again, work out that language to make it sound a lot better. I'll have 4 remain similar to what it is, but I'm going to have the general admonishment there, but to offer, kind of that final thing, that final statement that otherwise, if you can't contact court personnel, you have to provide notice to the opposing party. That is that we understand, we recognize that is a requirement here, that simultaneously copying is not going to be any good. Or is not going to exempt it from being classified as ex parte. The I guess inquiry that's been in my head as we've been talking about this is perhaps, do we need to make number 6 that much more simple, and really change it to say, maybe even put it as kind of switch its spot with number 5, so that it's following number 4, and basically say, does the analysis in opinion number 4 change if lawyer A is in an emergency situation and needs to communicate his unavailability in an emergency? And the answer is just going to be no. The opinion number 4, and that way that way we're not kind of mincing words and potentially creating well, it's okay under this scenario or whatever. We'll just have to say no. And then of course 5 comes in. 5 is where we talk about the merits, and kind of regardless of whether it's ex parte or not, you cannot communicate with the merits or communicate about the merits. So I
like that. I think that flows better.
Yeah, I go along with that.
Okay, I will. I know we've hit an hour, so I want to be respectful of everyone's time. But I'm going to sit down and see if I can make these changes this afternoon and send it out to you all. Judge, I know you wanted to have an opinion for the committee's consideration next week. So what I would suggest is I'm going to send something out, and if you all, if I've hit the nail on the head, just email me directly, and I would just ask you to send the communication to me instead of hitting reply all, because we may run into an open meetings issue of everybody's replying simultaneously, and that's actually a meeting. So if you'll just respond to me, then I can report to the committee that, hey, I think we have something here, and Judge, if you want to at that point recommend its publication, then we can. And if we still need to work on it, then we'll come back after the meeting next week and see if we can get something hammered out.
I think that sounds like a good plan, Brian. If we can get consensus and get it to the full committee next week, that would be wonderful. If we need to return subcommittee, then so be it. But it has been around a long time, and I'd love to get it resolved.
I would too, and I'm sorry if I've.
No, I think this goes to the issue. It is a difficult issue. It's not very black and white, and that's what makes it so challenging.
Yeah, and to that end, Judge, if you wanted to, if we wanted to hold another subcommittee meeting, I don't know what the rest of the week looks like, and even heading up to the meeting next week, the full ethics committee meeting next Thursday. But if you really wanted to schedule something, then by all means, let me know. I know I can make time, and we'll see if there's just a couple of things that we want to talk through if we reach that point. But let's kind of start with this first step, see if we have consensus based upon the revision, and go from there.
I think we're getting really close, I think.
Yeah, I do too. And we'll try to avoid another meeting if we can. I know everybody's got a full plate next week.
Right.
But, okay. Well, thanks everybody. If anyone has any other input, feel free to send it directly to Brian. Okay.
Thanks, Paul.
Hope everybody has a great day. Happy Monday.
You too.
Thank you, everyone.
Have a good week.
Bye, Missy.